We're now ready for the second paper on this panel, which is about the fiduciary duty of loyalty. And for that, we have Gabriel Rauterberg from University of Michigan. As soon as he gets mic'd up.
All right, wonderful. Thank you very much for having me. Thank you to the Indira Gandhi Institute of Development Research. Thank you to Vanderbilt. It's a great pleasure to be here. It's been about a decade since I was last in Mumbai, and last time I was here, I stayed in a hostel for $1 a night, so my conditions have improved. You know, last time I came to explore my Indian heritage, now I get to talk about contracting out of the duty of loyalty. And it's just been tremendously exciting. You know, in America, corporate law often concentrates on a small bundle of issues, and talking to people here about the incredibly interesting, different, heterogeneous corporate law issues has been incredibly exciting. There's just so much interesting work for scholars in the US to do in other countries. And Vic is about the only person who's actually taken this opportunity so far. So it's very exciting to be here. Okay, so I'm going to talk about contracting out of the duty of loyalty. This is an empirical paper studying this. And the background law I'll run over because there are a lot of economists here. But happily, the fundamental law is actually pretty similar in India and the United States. And the fundamental law is the people who run corporations, their officers, their directors / promoters, owe the corporation a duty of loyalty, a duty to act in the corporation's best interests and to avoid conflicts of interest. And actually, because we both descend from the English common law, we share an important part of the duty of loyalty, which is called the corporate opportunities doctrine. And the corporate opportunities doctrine forbids the people who run corporations, their fiduciaries, from appropriating new business opportunities for themselves. So you're Tim Cook, you're the CEO of Apple. Somebody comes up to you at a conference and says, I have an amazing new tech venture idea. You can't just take that opportunity for yourself and invest in it. You need to present it to the Apple board first, and only once the Apple boards decline to take that opportunity may you take it. If you take it for yourself, you're violating the duty of loyalty via the corporate opportunities doctrine. Now, most of US corporate law is default rules. That is, laws that apply to you unless you choose to put something different in your charter and bylaws. I had a hard time trying to figure out if this is exactly true in India, but I think it's pretty similar, that most of it's default rules, but there are some mandatory rules. The centerpiece of US mandatory corporate law has traditionally been the duty of loyalty. You can't opt out of the duty of loyalty until the year 2000, when Delaware, which is where most public corporations are incorporated in the United States, passed an interesting law. The law, we can see the text here. It's section 122.17. You don't need to read the whole thing. The gist is, 122.17 said, you as a corporation are empowered to authorize your fiduciaries to take business opportunities for themselves if you want to do so. It rendered the duty of loyalty as a mere default rule as it concerns the corporate opportunities doctrine. So why should we care about this? There are a couple of motivations. One is a series of interesting questions about whether market forces promote optimal corporate governance arrangements. If we allow corporations to have only default rules, that is to decide exactly what kind of corporate governance do they want for themselves, do they adopt good arrangements? Do they even notice that the rules are default rules? A kind of stylized fact about American corporate governance is that corporations do very little to tailor their charters. That's kind of a stylized fact that comes down to us that's deeply in tension with the findings I'll talk about here. Okay, another reason to care about the duty of loyalty in particular is what's a great normative question about corporations is whose interests should they serve? Whose interests do corporations exist to serve? And interestingly, the duty of loyalty is kind of the legal aperture where this question is confronted in the law, where the law says, okay, you're obliged to serve someone's interests, let's define it. And so what this law, Delaware change of the law, does is it kind of opens it up for corporations to decide for themselves who do we want to serve, because they can contract out of the duty of loyalty. Okay, so those are a couple of reasons to care about this in general. Okay, so this is the law. In America, for a long time, we've had 102b7, which allows corporations to waive liability, money damages for their fiduciaries for breaching the duty of care, for their directors for breaching the duty of care. However, you have to put that in your charter, the Articles of Incorporation, the foundational document. for your corporation. Not true with 122.17. 122.17 allows you to waive the corporate opportunities doctrine in any document for your fiduciaries. Okay, since it was passed, 8 other states have adopted cognate laws. So why might you be interested in doing this? Like, why would this idea even occur to you? And why was there pressure on Delaware to adopt this? Well, I think it's a story, and this is quasi-speculative, but it's a story of the growth of financing models in the United States that involved fiduciaries serving on multiple boards, and thus placing pressure on financial sponsors to be caught up in intractable fiduciary conflicts. If you serve on the board of 3, and I'll look at this in a second, but here you can see the growth of venture capital partnerships and private equity and how it roughly coincides with the passage of this Delaware Amendment in the year 2000. Okay, so here's an example of why you might want a waiver of the corporate opportunities doctrine. So this is Prosper. Prosper was the first and still one of the largest peer-to-peer lending markets in the United States. And when Prosper went public, it had a 7-member board of directors, the ultimate controlling board for the company. 4 of them were outside directors. And they were all kind of either venture capital or private equity principals, people from these firms. And each of them served on the boards of directors of multiple other companies, at least some of which were direct competitors with Prosper. Other financially savvy companies that potentially were opening up financial markets. So this creates the prospect of intractable fiduciary conflicts, right? Robert Cagle, you run across an interesting new business opportunity for developing a financial market. Do you give it to eBay or do you give it to Prosper, right? So what does Prosper do in response to these fiduciary conflicts? It adopts a waiver. This waiver is very long, so I've pasted here a much simpler one. This is an example of a corporate opportunities waiver. It says, be it resolved that the company waives Mr. Ellison, Larry Ellison's obligation to the extent it exists to present corporate opportunities to the company. So this is an example of after 122.17 is passed, corporations making use of their new... I feel slightly like very teched up here. Okay, so we asked 3 questions. 1, are there plausible reasons to believe there's an efficiency case for these waivers? 2, what have public companies done in response? Has this been a popular change in the law? And 3rd, can we offer a welfare assessment? And I'll focus on question 1, because I think question number 2, because I think that's our most powerful contribution here. But we do some stuff on 1 and 3 as well. All right, 1 and 3. So 1, we offer some reasons why this could be efficient. 2, we look at whether it's been adopted. And 3, there don't seem to be adverse welfare effects. So here's in a nub why it could be efficient for your firm to adopt a waiver. Essentially, in the context of modern corporate structures, fiduciaries, like venture capital principals or controlling shareholders, may sometimes be more efficient appropriators of new business opportunities than the firms for which they serve as fiduciaries. That means when the person is choosing whether or not to join your firm, whether or not to finance your company, they may actually be the better pursuer of certain new future business opportunities, and you may be willing to cede that to them ex ante contractually in return for their mutually advantageous participation in your company. Okay, I'm going to skip over this because I'm running out of time even quicker than I thought I would. But this is essentially the methodology for how we answer the descriptive question of whether corporations have made use of this. Technology is amazing. We download the entirety of the US's financial disclosure database, 22 million documents onto our local computers. We run a Boolean search through it. We find 24,000 candidate waivers. We code 1,000 with Eric and I, and then a team of research assistants. And what do we find? The corporate opportunities waivers, by the way, that's a bad joke. So what do we find? This is the central empirical fact in the paper. Over 1,000 public corporations have adopted a waiver of the corporate opportunities doctrine. So we find that when the law empowers corporations to opt out of the duty of loyalty, there's an enormous appetite for doing so. So we find 400 unique issuers in our hand-coded database. Then we use a fairly simple neural net to code the remainder of the 10,000 unique snippets. And we think there are about 1,500 unique issuers out there that have adopted a corporate opportunity waiver. All right, so here's a couple of simple facts about those waivers. Even though they're not required to be in your corporate charter, most of them are. The vast majority show up in the corporate charters. There are a trickle in the bylaws, and then some show up in things like employment contracts. What do? Well, they mostly apply to directors. Directors are the most common class of fiduciaries, and that's the healthiest place to have a waiver. You could easily see why a director on multiple boards might need a waiver. This is pretty unhealthy. If you're waiving all opportunities for your CEO, I'm a little worried. Why is your company in business if you think your CEO is better personally at pursuing all new business opportunities? So there might be some unhealthy things going on here. But some corporations waive all corporate opportunities, some waive all but a certain class, and some specifically specify which opportunities they're waiving. Okay, this is the machine learning algorithm we use and the kind of disclosures which we find. This is a little inside baseball because it's all US disclosure stuff. Okay, here's some stats. Once you note that about 1,500 public corporations have made use of this power, can you say anything about whether it's been for the good or ill? So the first thing we note is descriptively, the kind of corporations that adopt these waivers are healthy corporations. These are not the bottom feeders of the corporate ecosystem. So this is your first source of comfort. The kind of corporations that adopt a waiver of the corporate opportunities doctrine don't seem to be any worse than your average company in the public databases. Okay, what about running an event study? We do a ton of event studies in the paper, and all of them are subject to some pretty serious interpretational problems that I can't get into here. The bottom line is there's not a negative stock market reaction to the average disclosure of a waiver. Beyond that, I don't think you can say much with confidence. We find that for some windows, there's a statistically significant positive reaction to these waivers. But one of the main problems with interpreting them is you almost never disclose a naked waiver, just a waiver of the corporate opportunities doctrine. You tend to disclose something of the following. Larry Ellison has just joined our board. Great news. We waive the corporate opportunities doctrine as to him. And the net reaction is positive. But how can we tell whether, if the waiver alone, what work it's doing there? Proponents of the waiver say, without the waiver, he'd never have joined the board at all. Okay, so let me wrap up. The basic story is there's been an enormously popular reaction to adopting waivers of the corporate opportunities doctrine. The welfare effects are difficult to assess, but don't seem to be strongly negative. So what are some of the lessons here for India? Well, thinking about, if you're somebody who thinks market forces work for the well, then the straight-out fact that this is very popular among corporations should lead one to think maybe we should think about loosening up the constraints of the duty of loyalty. And in any event, I think the paper suggests some of the sort of empirical techniques we can use as data advances and as technology advances for answering systematic empirical questions about corporate governance. And this is an incredible country for doing that because of the popularity of controlling shareholders and thus the potentially heterogeneous corporate governance arrangements out there. So thank you very much.
Okay, so now we have Adam Feibelman.
And if it's okay, I don't have a PowerPoint presentation, so if I can just talk from here. So first, thanks to Yesha and others who asked me to be the discussant on this paper. It's a really fascinating and fun paper. This is not my field, but I can tell it's quite clear that it's an important contribution. Also, it's a very kind of refined, I sense nearly complete paper and very careful in its claims. So as a discussant, there aren't many kind of lines of attack available. And the summary just now was rather comprehensive. So most of my comments are kind of on the periphery of the paper itself, maybe charitably characterized as thoughts for future research, and then a couple of comments or maybe queries about the substance of the paper. And I'll kind of go in the order of things that were interesting to me to ask, maybe not most relevant to others. But the thing that I'm kind of was most curious about is the political economy of this story. So the number of states that have, it's kind of an odd group of states. and it's quite used in the states that have adopted it. But so the one initial question is, why haven't more states, especially kind of bellwether states, adopted it, and why have the states that haven't adopted it not adopted the ability to waive, right, corporate waiver? And this may tell us something about the issues that you're interested in. So, are there particular issues? Have there been efforts in other states to do it? Were these kind of shot down? Is there lobbying in states? Who's doing the lobbying and for what? I mean, it's a very different type of empirical study, but I think it would be quite interesting to know. I'm interested in whether your data set is on public firms, obviously, because of the data that's available. I'm curious if you have any sense about the practice among private firms that aren't in your data set, just kind of anecdotally or having kind of plowed this general area. That would be interesting to know. I'm also curious to know what we know, if anything, about the experience of in the absence of these waivers. So, right, in a world in which the waivers aren't available, and so you have the kind of general operation of the doctrine is required, where if an opportunity arises, the director or officer has to go to the firm and asks for permission. Do we know anything about whether that authority tends to be granted or not? My assumption is the cases that arise are cases in which the opportunity was not provided, and then it turns out to be quite profitable, and then there's a dispute about whether this was a corporate opportunity or not. It would be in kind of assessing the utility of the ability to waive, right, which you discussed, kind of the benefits ex post versus ex ante. It would be interesting to know if officers and directors get pushback when they actually disclose the opportunity and seek. If it's routinely granted, then the utility of being able to waive might be less. So those are things kind of on the periphery. Then 2 or 3 comments on the substance itself, and one just occurred to me during the presentation, because I guess I hadn't, and I should go back. I don't have the opportunity of going back and flipping through the paper, but the graph that you showed of the data of the adoption of the waivers had this sharp drop-off.
Oh, that's just because we haven't finished
Okay.
data for 2016.
Okay. And I'm sure you say that in the paper, and I just didn't. Okay, so then the other 2 are more kind of go to the substance of the kind of punchline. One is this this discussion of transaction costs and the kind of ex ante versus ex post. And I wonder, you talk mostly about the transaction costs of getting a kind of a waiver in the ex post world where getting authority in the ex post world where there isn't a waiver ex ante. And I wonder if you're underestimating the transaction costs of obtaining a waiver in the first instance. So it could be that the negotiating over this at the transaction stage can actually damage the relationship at the threshold in ways that would be quite difficult to measure, but could be operable. And that's just one observation. The second is that I found myself a little hesitant about the overall framing of the punchline, which I understand to be, and maybe you can correct me if I'm wrong, is that the value for the parties that adopt, at least the concerns about the effect on the parties that people have are overblown, and that maybe what I think you seem to want to say is that given the fact that there isn't a market penalty and that there's some evidence that there's a kind of favorable market reaction, that maybe we should think presumptively there's value here for the parties, right? It's a very careful, you don't actually say that, but that's kind of the gist. But then you have this discussion that I found actually quite plausible about the potential that the value would be in the anti-competitive effects, at least in many cases, where the overlap gives rise to the ability for some kind of coordination anti-competitive effect, and that's actually the value for the parties in adopting it. So one possibility is if you're right about that, then that could be swamping kind of the actual negative effects to the parties absent that anti-competitive effect. And I think actually you say that in the paper, but you say that kind of pretty far down in the paper. And so I guess I'm raising it now in part because I'm curious of whether you think that's a fair claim, and then also if it's useful in rethinking where that disclaimer arises. Thanks.
Okay, let's have some questions. Okay, again, let's just go around. Oh my God, way too many questions. But let's just go around the room, starting with Anjali.
So I just have a simple question. In India, we have a concept of two types of directors, executive and non-executive. And the question is, so it would really worry me if the executive directors should get a waiver of this sort, but a non-executive or independent director getting this kind of a waiver to me appears to be a different sort of thing. Does a similar concept apply even in the US?
Hi, very much enjoyed the papers, just two quick thoughts, mainly questions. So you mentioned that there are waivers with respect to shareholders as well. In the Indian context, of course, most firms are controlled by promoters. It'd be interesting to see if you break that out as a group, what effect you're getting in the US. You can treat that as probably a floor for what the effect would be in India in some ways, just because of the greater prevalence and the sort of looser governance norms. The other thing is, in terms of if the objective of allowing for these waivers is to induce more directors who have conflicts, let's say, or potential conflicts to sit on boards, then you might be able to test that directly. That is, do we actually see now in those companies that have adopted the waivers or that industry an increase in incidence of board members who have more conflicts than they did before? That would help you to address a potential response, which is that these waivers are just kind of a small form of insurance. No one really sues anybody over corporate opportunity stuff, let's say, and that this is just a way to sort of induce people who might otherwise be sitting on the fence. If that's true, that would provide you with some nice evidence that you wouldn't have the problem you have with the other things, that the news is clubbed with other things. That's just a direct effect that you would expect to see.
Yes, so this is a very interesting paper, and I enjoyed reading it. And actually, I haven't read it. I enjoyed your talk, and I look forward to reading it. I'm a little puzzled as to what exactly the change in the law was, because the standard under the Braz case was that if the board member discloses the opportunity and it's rejected by the corporation, this is a protection for it, and that's precisely what the law provides, is that if they disclose it and the corporation doesn't take it, then they can go ahead for it. So and yet apparently a lot of people thought there was a change in the law because people went to the trouble to adopt these waivers. So what exactly was the change in the law here? And then just another minor point, which is that your results could be that the adoption of a waiver is a signal that we've got a particularly interesting board member, and you sort of say that, but that would, the price might have gone up even further when you got that board member on if they hadn't had the waiver. So I'm not sure that showing that the price goes up when the waiver is adopted necessarily means that it was a good idea for the company.
Yeah, thanks for the paper. One question I had was on similar lines. There is this Roe versus Wade case in the United States, which affected not just the United States, but a lot of other countries around the world. So in that context, before the 2000 law, what happened that Delaware passed the 2000 law? Because in India, you've got a general listing of duty and care, good faith. There's no binding principle, to my knowledge, that somebody has to disclose to the board of directors that I'm interested in investing in this company or that company.
Great. Okay, wonderful. Well, thanks. One more, two more. Sorry about that.
I'll be super quick. So I just wanted to raise the role of creditors, in particular creditors in the case of events of default are very careful about what directors do. And in this context, I was wondering, to the extent there's some private oversight of these waivers, to what extent will creditors intervene to restrict the operation of any waivers, or maybe to persuade CEOs not to engage in sort of taking up different opportunities and so on?
Can I? First, I sure hope university professors are not subject to the corporate opportunities waiver law. And if they are not, I think it's been good for society in many ways. Anyway, my substantive comment was, I wonder whether this duty of loyalty ever really had any serious bite. And that is why you do not really see any reaction to what the enforcement of the law. I would think that there would be a very large number of cases where people have left organizations, people in key fiduciary positions have left organizations, set up their own businesses. And it would be a very gray area that, how many of those businesses would not have arisen because of opportunities which arose as a result of their fiduciary responsibilities. And it would probably be a very difficult thing to prove if one actually wanted to go against the person. So how many such cases exist of anybody being actually sued for it? Does it really have any substantive bite in any way?
Great. Gabriel, quickly.
Okay, great. I think Adam undersold his comments. Those are really great, thought-provoking comments. So I haven't thought about the political economy if exactly. The states that adopt them are kind of states that experiment in corporate governance reform. So that's maybe the most I can say, but I definitely should think about that more. Sorry about that. As for, would private companies do a lot of this? You'd expect private companies to do it all the more, because in general, our stylized understanding is private companies engage in a lot more charter innovation and tailoring than public corporations. And we do see some private corporations in our data set, just because some private corporations are being spun off from a public corporation or have some relationship where they are disclosed as part of the public corporation. And as for how do you handle fiduciary conflicts in practice, lawyers have told me that no one ever presents an opportunity they want to their board. They just take it, and maybe they get sued afterwards. So you never actually tell your board about an opportunity. But that's, I don't know whether that's true. That's the anecdotal story I've heard. Okay, so I'll try to go really quickly. The first question about I think the first question was executive versus non-executive directors. And that sort of, I think, maps on to directors versus officers who are also directors in the United States. Totally share your intuition that it's more troubling to have a waiver as to the operational executives who serve on the board. Nonetheless, we do see some waivers, and that's food for thought. I think the efficiency case for those waivers is lower. So I totally agree with the sentiment there. Vivek, obviously great questions, and yeah, I should just try to. One, isolate for controlling shareholders. That would have the most to tell us, certainly in terms of transplanting this logic to India and maybe the other countries which controlling shareholders have a larger role. And then testing directly for the instance of directors, also something. If this was a lot of work, so that would probably be a lot of work, but sufficiently worth doing that I should probably still try to do it. And Eric, I do want to build this paper out, so something I will keep in mind. A change in the law. I guess the main change in the law was Delaware allowed you could always ex post waive. So any opportunity once presented to the board could waive it and reject it, and thus the fiduciary could take it. But Delaware case law prior to 2000 said you cannot engage in an ex ante waiver. So a company could not authorize their CEO, Margaret Blair, to just take whatever business opportunities she runs into in the future. They couldn't say, 5 years from now, you don't need to present it to us. You can just take it. So the Delaware Chancery Court had said that's unlawful, the attempt to do that. And so that's the change of the law, the ex ante authorization. So thank you. And then the question about the transplantability of this to other jurisdictions. So the case Siegman, who had said this is unlawful, created a lot of pressure in Delaware to try to amend the law. And there's obviously, it's sort of migrated to other jurisdictions in the United States, and the American Law Institute has thought about putting it in the principles of corporate governance. I haven't seen it being taken up in other jurisdictions. It's a great question. I should try to look at its global reach. All right. Creditors, great question, Yesha. I haven't thought about creditors and looking for them. I have seen some equity investors who push back against waivers. So Vanguard shows up and contacts a firm and says, look, I just saw the waiver you adopted. It's too broad. I see the logic, I see the efficiency consequences, but maybe it should just be for the independent directors and not for the officers. So I have observed some pushback. And then the last question is, how much bite does the duty of loyalty have in general? I think we have a lot of evidence that the duty of loyalty writ large has a lot of bite. It's a huge amount of litigation. It's the only part of fiduciary law that's heavily litigated in the United States, and we use it to regulate an enormous amount of corporate behavior. What about the corporate opportunities doctrine per se? There, the evidence is a little messier. We do have a bunch of cases. It's certainly litigated, and as far as I can tell, there's only one case in India. And I don't know whether that reflects generally that the duty of loyalty jurisprudence is less developed in Indian case law, whether I'm not that good at researching Indian case law, which is also highly probable. But in the United States, the corporate opportunity doctrine is actually a fairly well litigated doctrine. Could I try to infer how much of a problem it is? That I'm not sure. But I do think there's some bite. There's a lot of bite to the duty of loyalty writ large, and there's some bite to the corporate opportunities doctrine. So thank you all for the very great comments.
Okay.